May I please, Your Lordship? Your Lordship, I beg to mention item number 5. I pray for 2 weeks' time, Your Lordship.
Why? Is it 2023 matter?
The conducting counsel is having some personal difficulties.
No objection. For responding to you.
Miss letter counsel for the petitioner has sought for a completion on the ground that the learned conducting counsel is having some personal difficulty today. On no objection be on the respondent having no objection to the prayer, seems allowed. List this matter after 2 weeks.
Obliged.
Highly obliged.
Please, Lordship. I beg to mention item 6, Lordship. This was what is regarding the Transport Department, which is pending in the Supreme Court. It may be taken up after 4 weeks. We wait the outcome of the regarding the appointment of.
Yes, but I think I recall you said that this matter is separate from the others.
Lordship, then we had gone through. There is some bearing, Lordship. So that is why it has been from the last few occasions. It has been adjourned in view of the pendency of the matter before.
Those two related matters have also been,
Those are in a different bench.
or different bench.
Yes.
Oh, I thought this bench. Then this matter should have gone to the.
We will try to make a mention, Your Lordship, before the appropriate bench.
Same subject matter,
Lordship, yes.
Connected.
same issue,
Yes.
all connected. They should be taken up by.
By the same bench. Your Lordship.
On prayer made by the letter counsel of the petitioner, who has submitted that the Honorable Supreme Court is seasoned of a matter which is directly connected to the issue sought to be raised by the petitioner herein. In this case, it is therefore prayed that pending such disposal by the apex court, this matter may be kept, may be adjourned for the time being. As prayed for, this is matter after 3 weeks. 3 weeks.
Apply.
Obliged.
From daily list, item number 1.
Lordship, here Lordship, inadvertently the copy of the FIR was not enclosed, although the form 154 Lordship, that is at page 30, has been enclosed, but the copy of the FIR. So I just pray for 1 day time, Lordship. I'll file by way of affidavit, only that FIR, Lordship. Day after tomorrow, Lordship.
On prayer made by Mr. Sheikh, letter counsel for the petitioner. This is matter
Day after tomorrow, Lordship.
on 13.
Master.
Item number 2.
Your Lordship will file the additional affidavit during the course of the day. Affidavit, we're supposed to file one affidavit
You are for?
for the project director on behalf of Ms.
Oh, that.
Charity.
Okay.
The last occasion,
Condonation
if
of
your Lordship
delay.
recollects,
Yes.
they were supposed to file on that same day in course of the day and supply me a copy. Copies were never supplied, nor it was filed.
We'll file today, Your Lordship, during the course of the day.
Yes, the last order was passed on 4th.
Lordship.
I said the last order was passed on 4th.
Your Lordship.
And what reply is there? What is necessary? You have filed an application seeking condonation. They have opposed that. Simple as that.
And in the
Where is the
condonation
question of
application
rejoinder?
also, Your Lordship, no sufficient cause was made out, and there was a concealment of material facts.
That is, when the merits is looked into, all those issues will be taken up.
Your Lordship.
But then, as far as pleadings are concerned, I don't think it's necessary. And why, if it's only if there are new facts or new materials brought in by
The new facts which they have submitted, Your Lordship, they were saying that there was a CBI case.
that is their ground. In your affidavit, if you have raised any new facts apart from the pleadings,
Your Lordship, I brought in some records also, Your Lordship.
so in that case you have to give them opportunity to
It was, in fact, it was heard also, Your Lordship.
So tomorrow,
Oh, okay.
tomorrow,
Okay.
Your Lordship.
Yes, sir.
Mr. Learned Counsel has sought for accommodation for the day on the ground that the Learned Conducting Counsel is indisposed. Accordingly, as prayed for, this is matter tomorrow.
Applied to Lordship.
Item number 3.
My lord, the settlement is at advanced stage, so we'll need some more time.
See, okay, this court has got no control over how the settlement will progress.
Absolutely, my lord.
Eventually, it may turn out this way or that way. But the only thing is that you have to ensure that there is a possibility of settlement. Number one.
On principle, parties have agreed to settle, and it is in progress.
And number two, there must be some definite,
My lord.
conclusion to the matter. Otherwise, after, I'm just saying, suppose the 1 year you come and say we can't do anything about it, then we go back to square one. How long?
My lord, after 2 weeks. Let it be 3 weeks, my lord. No,
The counsel for the respective parties have submitted that there is a positive development in the ongoing process of settlement and negotiation between the parties, which may culminate in finally settling of the matter, and as such it is prayed that some more time may be allowed for the process to be completed. As prayed for, this is matter up to pray allowed, this is matter up to as prayed for, this is matter up to 3 weeks.
Item number 4.
Lordship, item number 7 is for condonation. That should be taken.
Are you party there?
Item number 7. Item number 4 we have not made issue notice. It's a main appeal. Item number 4 is the main appeal. We are the appellant here.
Yes.
But then another cross appeal has been filed by the NHA.
Cross appeal has been filed, for which application for condonation of delay has been
filed, which is at item number 7.
Not item number 7. That was item number.
Item number 7.
7.
Different claimants here.
That was item number 2 is a different one.
Okay.
I think one of the same stretch, but a different claimant.
Oh, I thought it's one and the same thing.
Yes.
Okay. And item number 7, you see.
Yes.
Oh, this is where the cross appeal has been filed.
Yes. As far as 4 is
And
concerned,
that has been filed.
Yes.
Then a matter will proceed then.
Yes, but that delay has to be condoned. And in my humble submission,
delay. Okay. Delay here also has been filed. Condonation of delay.
In item number 7. As far as item number 4 is concerned, I have finished my argument. It's for the government to reply.
Lordship will recall the understanding was that their cross appeal and the main appeal will be heard together.
Exactly.
So
That cross appeal has not been admitted as yet.
Exactly.
To be
So
heard together, where is the question
so
of...
that application may be heard today.
We are at that stage then.
Wait, that's changed.
where we can't proceed, you see, unless, because since there is a cross appeal
There's a cross.
involving the same,
So item number 7, it's the condonation.
End of the board, Your Lordship. We please to take this matter at the end of the board because the council, she's
Why?
coming.
She's always never on time. End of the board, then it will be at 4 o'clock in the evening.
We'll see then, we'll wait. End of the board.
Right, Your Lord.
Item number 8.
Lordship, on last question, Your Lordship was pleased to allow the party to advance the argument on other issues relating to the quantification of claim. Now, I'll just first take to the issues which were framed by the tribunal, page 16, 1-6.
Page 16.
Page 1-6.
Paper book.
Paper book. Issues allowed.
Yes.
There are 5 issues. Whether the claimant husband, namely so and so, died in the road traffic accident on 11/6/2014 at Nongko proper NH GS Road, below Nongko Police Station, Rivai, involving truck bearing number so and so, which was caused due to rash and negligent driving of the driver of the said truck. This issue has already been was decided by the trial court, and I have filed the appeal against it, and that issue has been already heard. Hearing is concluded. Now, this issue is also related to issue number 5. So, actually, issue number 1 and 5 stands decided by the trial court, and this Honorable Court on Appeal has also heard on this issue. What is left out now? Issue number 2, 3, 4. To what amount the claimant is entitled, whether the claimant is entitled to interest, whether the OP New India Assurance Company Limited is liable to pay any compensation to the claimant or indemnify the owner of the truck. Now, these issues relates to the quantification of the claim, to what amount the claimant is entitled to, and also the interest and liability of the insurance company. So far, liability of the insurance company is concerned, they have not denied the insurance policy, though the insurance policy has not come on the record, but nevertheless, they have not denied it. And there is nothing to show violation of section 149(2), and they have taken over the defense of the owner and driver also. Now, what is required now, that quantification of the claim, Your Lordship. For quantification of the claim, Your Lordship, the Supreme Court, as on date, has standardized the things. Standardize the claim and the principle how it has to be determined. There is hardly any scope left out where the discretion could be exercised, save and except in few areas, Your Lordship. Now, in that for that purpose, Your Lordship, which one you have given? मेरे वाला copy. I am giving one small notes which will clarify the law as it stands today. Paragraph number 1.2, Lordship got it. Paragraph 1.2, the general principle for ascertaining the compensation in case of death are well standardized by the Honorable Apex Court. The Apex Court in the case of General Manager Kerala State Transport Corporation versus Susama Thomas and others, 1994 2 SCC 176 at para 16 of the judgment, has emphasized the multiplier method for ascertaining the compensation in the case of death by stating that it is necessary to reiterate that the multiplier method is logically sound and legally well established. We indicate that the multiplier method is the appropriate method, a departure from which can only be justified in rare and extraordinary circumstances and in very exceptional cases. So, Your Lordship, the Supreme Court is very clear. This law is laid down in the Susama Thomas that multiplier method is the most acceptable method, and departure from this multiplier method can be done only in rare to rare cases. Otherwise, the compensation is to be ascertained by following the multiplier method. Now, next para, Your Lordship. The Apex Court, while explaining the multiplier method in the above case at para 17, held as under. This para 17 in the Susama Thomas case only. I have quoted here. Instead of taking the book, I have quoted this para here. The multiplier represents the number of years purchased on which the loss of dependency is capitalized. Take for instance a case where annual loss of dependency is rupees 10,000, and if a sum of rupees 1 lakh is invested at 10% annual interest, the interest will take care of the dependency perpetually. The multiplier in this case works out to be 10. If the rate of interest is 5% per annum and not 10%, then the multiplier needed to capitalize the loss of annual dependency at rupees 10,000 would be 20. Then the multiplier, that is the number of years purchase of 20, will yield the annual dependency perpetually. Then allowance to some scale, the multiplier would have to be made taking into account the uncertainty of future, the allowances for immediate lump sum payment, the period over which the dependency is to lost being shorter, and the capital feed also to be spent away, period of dependency is to last, etc. Usually in English court, the operative multiplier rarely exceeds 16 as maximum. This will come down accordingly as the age of the deceased person or that of the dependent, whichever is higher, goes up. So, Your Lordship, this case I am setting it for the purpose of impressing upon the court that multiplier method is the acceptable method, and departure from it can only be done in rare to rare cases. Then, Your Lordship, I take this court to the most important judgment in the Sarla Verma and others versus Delhi Transport Corporation and another 2009 6 SCC 121. The Apex Court at para 18, 19, 30 and 42 has laid down the respective role of the claimant and the tribunal to assess the compensation, and addition and deduction to be made while assessing the compensation, and the said paras are quoted below. Your Honor, Lordship, this judgment is very important. This will show three things, Your Lordship. What claimant have to prove, then what tribunal has to decide, and so far the tribunal finding or decision is concerned, it is confined on the 2 points. What addition to be made in the income and what deduction to be made. This is the part of the tribunal. So far claimants are concerned, claimant have to establish only 3 things. Then paragraph 18, Your Lordship, basically only 3 facts need to be established by the claimant for assessing compensation in the case of death: the age of the deceased, income of the deceased, and the number of dependents. These are the only 3 areas where the evidence of the claimants are needed, and the claimant have to prove these 3 things. Then come the role of the tribunal. The issues to be determined by the tribunal to arrive at the loss of dependency are: additional deduction to be made for arriving at the income. Number 2, the deduction to be made towards the personal living expenses of the deceased. And number 3, multiplier to be applied with reference to the age of the deceased. If these determinations are standardized, there will be uniformity and consistency in the decision. There will be lesser need for detailed evidence. It will also be easier for the insurance company to settle accident claim without delay. Your Lordship, I may point out this is the Constitutional Bench judgment consisting of 7 judges, if I am not mistaken. Then paragraph 19, to have uniformity and consistency, the tribunal will determine the compensation in case of death by following well-settled steps. First step is ascertaining the multiply count. The income of the deceased per annum should be determined. Out of the said income, a deduction should be made in regard to the amount which the deceased would have spent on himself by way of personal and living expenses. The balance which is considered to be the contribution to the dependent family constitute the multiply count. Then step number 2, having regard to the age of the deceased and period of active service, the appropriate multiplier should be selected. This does not mean ascertaining the number of years he would have lived or worked but for the accident. Having regard to the several imponderables in life and economic factor, a table of multiplier with reference to age has been identified by this court. The multiplier should be chosen from the said table with reference to the age of the deceased. Then step number 3, the actual calculation to the family when multiplied by such multiplier gives the loss of dependency to the family. Therefore, thereafter, a conventional amount in the range of 500 to 10,000 may be added, or loss of estate where the deceased is survived by his widow. Another conventional amount in the range of 500 to 10,000 should be added under the head of loss of consortium, but no amount is to be awarded under the head of pain, suffering, etc. Your Lordship. This part is modified in the subsequent judgment, last part. The funeral expenses, cost of transportation of the body if incurred, the cost of any medical treatment of the deceased before death shall also be added. Paragraph number 30. Though in some cases the deduction is to be made towards personal and living expenses, is calculated on the basis of the unit indicated in the Lok Chandra. the general practice is to apply standardized deduction. What deduction to be made, Your Lordship? Having considered several subsequent decisions of this court, we are of the view that where the deceased was married, the deduction towards personal and living expenses of the deceased should be 1/3. Where the number of dependent family member is 2 to 3, 1/4. Where the number of dependent family member is 4 to 6 and 1/5, where the number of dependent family number increases. So, Your Lordship, my case falls in the 4 to 6, and in the case of 4 to 6, where the number of dependent family member is 4 to 6. My family consists of 4, and therefore the deduction will be 1/5. Deduction will be 1/5. Then multiplier, Your Lordship will see paragraph 42. What multiplier to be taken is also not discretionary. By the judgment of the court, it has been finalized that at what age what multiplier should be taken. We therefore hold that the multiplier to be used should be as mentioned in column 4 of the table above, prepared by applying the Sushama Thomas, Trilok Chandra and Charlie, which start with an operative multiplier of 18 for the age group of 15 to 20 and 21 to 25 years, reduced by 1 unit for every 5 years, that is M17 for 26 to 30 years, M16 for 31 to 35 years, M15, M stand for multiplier, M15 for 36 to 40 years, M14 for 41 to 45 years. My case falls under multiplier 14 because at the time of the death, I was within this age group. So, Your Lordship, Sarla Devi case settled the issues that what deduction to be made. If the family, it depends on the number of the dependent. If number of dependent, if the deceased was recently married, had no children, then it is 1/3. And if he has children, 2 children, then including the wife, then it is 1/5, 1/4. Then further it is 1/5. My case falls under 1/5. These are the standardized guidelines here, and departure from it is only in very, very exceptional case. Then, Your Lordship, next, National Insurance Company Limited, Parne Sethi and others. This is Constitution. I am extremely sorry, sir. This is Constitution Bench judgment. The Constitution Bench of the Apex Court, comprising of 5 judges, had surveyed the entire case law on the issue of assessing the compensation, both in the case of death and injuries, and after discussing the entire case law, the Apex Court had summarized the law on the above point, and the relevant para, that is para 59, is quoted below. In view of aforesaid analysis, we proceed to record our conclusions. The 2-judge bench in Santosh Devi should have been well advised to refer the matter to a larger bench, and we are not concerned about this. Then 59.2, as Rajesh has not taken note of the decision of the Reshme, this is also we are not concerned. Then Your Lordship, come to paragraph 59.3. While determining the income, an addition of 50% of actual salary to the income of the deceased toward future prospect, where the deceased has a permanent job and was below the age of 40 years, should be made. The addition should be 30% if the age of the deceased was between 40 to 50. I fall under this category. Deduction is 30% if the age of the disease was between 40 to 50 years. In case the disease was between the age of 50 to 60 years, the addition should be 1/5 actual salary. This is, Your Lordship, future prospectus. Future prospectus, and how to calculate the future prospectus, the Supreme Court has already spelled out in paragraph 59.3. This is addition. Deduction, I have shown that if it depends on the number of the dependents. Then, Your Lordship, 59.4. And this, you will see 30% will be in the case of the regular employment. My husband was a regular employment in the government of Meghalaya in the office of the PWD, and his job is regular, and therefore paragraph 59.3 would be applicable, and paragraph 59.4 deals with where the disease was not having a regular employment. Then paragraph 59.4 will apply. Then, Your Lordship, the determination of the, I take to 59.5, the determination of the multiply count, the deduction for personal and living expenses, the tribunal and the court shall be guided by para 32 of the Sarla Verma. Constitution bench has approved the principle laid down by the Sarla Verma case in paragraph 32. The selection of multipliers shall be indicated in the table in Sarla Verma read with para 42, which I have already read, Your Lordship. So these things are approved by the Constitution bench. The age of the disease should be the basis for multiplying. Paragraph 59.8, Your Lordship, is also very important. Your Lordship will just see to it. Reasonable figures on conventional head, namely loss of estate, loss of consortiums, and funeral expenses should be rupees 15,000, 40,000, and rupees 15,000 respectively. Supreme Court has done away with the discretion. They put it a rule of thumb that in the case of death, what amount should be there for funeral expenses, loss of consortiums if he was married, and plus the funeral expenses and the loss of estate. Now, next line is important, your last line here. The aforesaid amount should be enhanced at the rate of 10% in every 3 years. Your Lordship, my case remained pending for 11 years. So this figure, whatever comes out, the total of these three should be enhanced at the rate of 10% after every 3 years. So 3 increment I get on this count. Then, Your Lordship, the next case is Atul Tiwari, which have again restated the law. Atul Tiwari versus Regional Manager. A division bench of the Apex Court at para 27, 28, 29 reiterated and follow para 9 and 16 of the Sushama Thomas case, para 18, 9 and 42 of the Sarla Verma case, and para 59 of Parnav Sethi case, and the set paras are that is para 27, 28 are reproduced. Here, Your Honor, in para 27, 28, 29, they are reiterating the law laid down in the Sushama's case, Sarla Verma case, and the Constitution bench judgment of the case, that is Parnav Sethi. So I am not bothering Your Lordship to read that.
Yes.
Then, Your Lordship, come to page 7. Page 7 also, this is reiteration of the earlier. Then paragraph 1.6, page 8. The appellants are also entitled to interest at the rate of 12% per annum as per section 171 of the Motor Vehicle Act. That is the date of filing the claim application till realization. In view of the fact that the respondent at every stage have delayed the matter and the case remained pending before the tribunal for more than a decade. Your Lordship here, Lordship will find from the order sheet. At every stage, they have taken adjournment of more than 1 year. For filing WS also 1 year. For suggested issue also, lot of time is taken. Then for evidence, 5 years they have taken, Your Lordship. So, in view of these facts on record, Your Lordship, I have prayed that interest should be 12%, Your Lordship. These are the principles which I have read it before Your Lordship. These are the principles of awarding the compensation in the case of death of a person. Then Your Lordship comes to the actual calculations. What is the actual calculation based upon the law laid down by the apex court in these cases, Your Lordship? Actual calculation on the basis of aforesaid law laid down by the apex court. As Your Lordship, I have pointed out, the claimant has to prove 3 things: age of the disease, and secondly, income of the disease and dependency. These 3 things are to be proved. Then Your Lordship, paragraph 2.1. As per para 18 of the Sarla Verma case, in a claim application for award of compensation in case of death, only 3 facts need to be established by the claimant of the disease. Age of the disease. The disease was born on 29/9/1969 and he died due to motor vehicle accident on 11/6/2014, and as such his age at the time of death was 44 years 9 months. And the same is proved by CW1 by exhibiting the admit card of the disease issued by embossed and marked as paper mark 1 after comparison with the original. Besides the service record exhibited by CW3, the disease was born on 29/9/1969. And the said relevant page is at page 82 of the paper book, Your Lordship. So there are evidence. Embossed certificate is there, his service book is there, which are produced by the office, wherein his date of birth is mentioned, and as per that, the disease at the time of the death was 44 years 9 months. Then Your Lordship, income of the disease. The disease during his lifetime was working in the office of the executive engineer PHE Sewage and drainage division in the capacity of a section officer. He was drawing a monthly salary of rupees 27,949 and the same was proved by CW3 Shri so-and-so, and he has produced and exhibited the service book as Exhibit 14 and salary certificate as Exhibit 5, Your Lordship. I'll just show the exhibit, that is Exhibit 5 salary certificate, which is at page 49 of the paper book. Just to clarify one thing.
Yes.
Page 49. यार खत्म का पैसा दे देगा, बंद देगा, पैसा तो मिलेगा, पैसा कहाँ जाएगा? Lordship, page 49. Now here Your Lordship will find the total is 27,949. Now GPF subscription is his own money. So then after deduction of the GPF money, the net amount is 26,949, but I am claiming the compensation on 27,949. For the reason, Your Lordship, that so far GPF contribution is concerned, that's the person's own saving. So this cannot be deducted from the salary. His salary is 27,949, and this deduction of GPF cannot be a part of the salary, or it has to be minus from the main salary, because this is his own contribution. The wife will get it after his death, Your Lordship. So his age of the disease and the salary are well proved by the exhibits which I have shown, as well as the evidence. Then number C, Your Lordship, dependency. The disease at the time of his death was survived by his wife Srimati Jennifer Dhar, aged about 39 years at the time of accident, and 3 minor children, namely Mrs. Vickers Jane W. Dhar, Master so-and-so, and Master Dembing so-and-so, and their age was 14 years.
Just go only to the relevant portion, not necessary to.
Pardon, sir?
Go only to the relevant portion, whatever.
Yes, this is only on one para, this dependency. This is the CW1 proved their age by producing and exhibiting admit card issued by MBOS as Exhibit 1, birth certificate, Exhibit 2, Exhibit 3 and Exhibit 4. These are there, Your Lordship. So far the age of the dependents are concerned, Your Lordship. Then 3 things what I was required to prove are proved. Then, Your Lordship, the question issue to be determined by the tribunal. Addition, Your Lordship. What addition to be made? My case falls under paragraph 59.3 of the Constitution Bench judgment Parnav Sethi. Now, Parnav Sethi and the income of the disease, and there addition should be 30%. I fall under the category of 30%. 30% of 27,949. That makes my salary for the purpose of computation of the compensation 36,333 by taking the future prospectus in the case of a government servant, Your Lordship. Then what deduction to be made? Deduction is to be made from this total amount of 36,333. Now deduction is, I have as per the judgment, and the age of the disease is 1/4. So 1/4 of 36,000 is to be minus, and after minusing that, it comes to 27,250. 27,250.27 per month, and yearly comes to 3,27,003.3. Therefore, the multiplicand in the instant case is 3,27,000 per annum. Therefore, to arrive at the total compensation, the multiplicand is to be modified by a suitable multiplier. And the choice of multiplier comes here as per the Sarla Verma case, paragraph 14, 1/4. And when this multiplicand is multiplied by 14, the total compensation payable to the claimant comes to 45,78,046. Now comes the conventional head. In the conventional head, three things are granted. A person may claim anything, whatever he likes, but Supreme Court said that only for these 3 things he is entitled. 15,000 loss of estate, loss of consortiums, and funeral expenses 15,000. Then 2014, this figure should increase 10% after every 3 years. In 2014, it was 70,000. After 3 years, it's 7,000 more increased. 2020, 7,000 more increase. 2023, 7,000 more increase. So this comes to, Your Lordship, total it comes to 91,000, and this 91,000 to be added to the 45 lakhs, then the total compensation which is payable as per the law strictly laid down by the apex court. There is nothing less, nothing more. These days all things are standardized, and this helps the insurance company to settle the claim, because scope of discretion by and large has been totally gone, save and except on the point of the interest portions. There is no standardized guidelines which have come as of date. So this is within the parameter, this is within the discretion of the court. Court will look into the aspects how the case was dealt in the trial court by the insurance company. And if Your Lordship have a glance on that, Lordship will find that they have delayed the settlement of the case or conclude the case within a reasonable period, and it dragged for 11 years. And that's all, Your Lordship.
हो गया और कुछ है? My lord, I'll just take
10 minutes.
Few minutes. Leave it to me. My lord, my learned friend made a marathon argument on the legal position. My lord, there cannot be two views. The cases which he has referred, my lord, these are the law is holding the field. Now he has to justify his case whether evidence on record supports his case. This is the very short point Your Lordship will look into. Now the question is whether the accidental truck, whether there is any evidence in regard to negligent driving in regard to the truck in question. Now Your Lordship will have to scan the evidence of the CW. There are CW2, he is admittedly an eyewitness, but whether he has stated correctly. Now he has stated, my lord, I have made a brief note, there are some typical mistake. My lord, Your Lordship will find he is a Preston Milliam, he is the eyewitness. Now what he has stated, Your Lordship, kindly see. In short, I have given it. In order to come to the precise conclusion whether claimant is entitled to any compensation, it is necessary to peruse the evidence of claimant as well as the opposite parties. Now the CW2, he is the, my lord, the eyewitness so far claimant is concerned. Now what he has stated, in the evidence in chief, this witness stated that on 11/6/2014, he along with deceased Collins Warjari were coming from Umsing towards Shillong in a Maruti car number so and so. He was sitting in the front seat. He further stated when the Maruti car reached at Nangpo PS, he saw a truck coming from opposite direction and on the wrong side of the road by overtaking another truck in a very high speed dashed the Maruti car on its front. He was
So this
badly
thing we
injured.
have already discussed while taking the negligence.
In a short manner, my lord, he is quite anxious about that position. That's why he did not argue on all that. He argued what does the Supreme Court has said. My lord, it is nobody's case. Supreme Court is rightly and is holding the field. My lord, why he has made a marathon argument on that?
Relating to the negligence.
Now, my negligent will have to be against the truck. That will have to
Last time
prove.
also he argued on a point which is not point.
Why you
Because
are-
no, you listen to me.
Ah.
He was not the insurer of the Maruti car. He is arguing as if he is in
that
insurance of the
position,
Maruti car.
what will become in that eventuality that I have highlighted. So, आप बैठिए ना. Don't disturb me. I did not disturb you.
Yes. You go ahead.
My lord, now your lordship will find this much he has said. Now this is against the eyewitness given by the two police personnel. They were posted on that very night there in order to give a Naka checking. Naka checking, as your lordship understand, there is a police barricade will be there. All the vehicles will be stopped for checking. After inspection, all the vehicles will be allowed to go. Now what happened, my lord, on that very night, I will read those evidence of the two eyewitnesses, the police personnel. Now they have stated they stopped this red Maruti car and he did not stop. They flouted the signal and in a very speedy manner by crossing other vehicles dashed the Maruti car which was standing in the opposite side. Now that is the case, and these police personnel are not interested witness. Now the CW2 is the witness of the claimant, obviously is an interested witness, and he could not narrate what way the truck is negligent. Now this is this your lordship has heard, and then another CW4 is also stated to be a eyewitness, but it's just a chance witness, my lord. If the evidence of CW2 succeeds, they can CW4 can get an advantage. Now your lordship kindly see OPW number 2, he is eyewitness, the sub-inspector of police, your lordship kindly see at page 2. On 11/6/2014 in the evening, we were detailed by the OC Nangpo PS for conducting highway vehicle checking. SI John Sangma was with me and some armed personnel whose names I do not recall now. In course of the vehicle checking at the highway, we stopped many vehicles and everybody obeyed our signal and stopped their vehicle for checking. Suddenly one red Maruti car in a rash driving came from Barneyhat side towards Shillong, and when we signaled the vehicle to stop, it did not stop but rushed forward and dashed the stationary truck on the opposite side. The incident I have witnessed with my own eyes, and the red color Maruti car was at fault. Now the statement of the eyewitness, that is the police, is very clear, very explicitly he has said that the Maruti car was at fault. Now in the cross, on the day of the incident, there were two occupants inside the red Maruti car. Maruti car overtook the vehicle that we were checking on that day. Lordship, kindly see this. Maruti car overtook the vehicle that we were checking on that day, because the other vehicles were stopped. They were checking. Now this Maruti car, he was signaled to stop there. He did not stop. In a rash manner he went through. Then OPW number 3. On 11/6/2014, we were on highway duty for Naka checking of all the vehicles passing through Nangpo. My colleague so-and-so was also with me on duty. At that relevant time, we were stopping the vehicles through that route and checking the vehicles. Suddenly, one red color Maruti vehicle going towards Shillong was stopped by us, but it did not stop. The said vehicle was driven in a very rash manner and almost hit my colleague who tried to stop it. The said Maruti car did not stop at our signal and went forward and hit one truck which was parked on the side of the road. We rushed to the spot and took out the driver of the Maruti car as well as the passenger. In the meantime, the traffic police came along with ambulance and took the injured to Nangpo Civil Hospital. I have seen the incident with my own eyes, and it was the fault of the driver of the Maruti car. Now the accident took place, this your lordship may skip. Then my lord, the last is the question whether you will agree with the suggestion that the person who is sitting beside the driver of the Maruti car is a better person to know the manner into which the accident took place. Well, my learned friend put a very wrong question to the witness. Now what is the reply, your lordship kindly see? The person sitting beside the driver of the Maruti car was drunk. He was the occupant. Well, my learned friend put a question whether that person who was sitting in the car, whether that would have been a better evidence. Now the eyewitness said that he was drunk. That was not necessary, we did not bring, but he has brought it. When my colleague tried to stop the Maruti car and the Maruti car did not stop, I started looking towards Guwahati side. Why they brought it, I don't know. I have seen that the truck which was parked had its half light. The light was on. From the perusal of eyewitness of claimant, that is CW2, no reliance can be placed as he was an interested witness, and his statement that the truck was offending vehicle could not be established at all by adducing any evidence. On the other hand, it is expressly clear that OPW number 2 and OPW number 3 were deputed of official NACA checking, which means checking point or a place where traffic is stopped for inspection. Both the eyewitnesses having no interest in the case, they were discharging their official duty. From their evidence, it has been established that driver of the red Maruti car did not stop on the signal given by them. On the contrary, it drove very rash and negligent manner and dashed against the truck on the opposite direction. Both the driver of the Maruti car as well as the CW2 were drunk. That is at page 100B, your lordship will find, and page 43, question number 15. At page, then another very interesting thing your lordship will find, at page 132 of the paper book, they have said that they might have, my lord, contributed to the accident in question. So therefore, the liability, so far they are concerned, may be 20 to 25%. Now they have come up to that level because they came to know that there is no evidence against the truck. So therefore, your lordship is required to see the evidence on record, specifically claimant's evidence CW2 and CW4, and so far the opposite parties are concerned, OPW number 2 and OPW 3. Now they are the eyewitnesses. Well, they were engaged by the police authority to check the route on that day, to stop all the coming vehicles. After inspection, all the vehicles were freed. Now that was not a free moving road, because every vehicle coming in that road, they will have to stop. But this person, he did not stop. And he did not stop, possibly he was also, my lord, under the influence of liquor, as your lordship will see at page 100B. So he thought, if I am caught, then there will be many problems. So therefore, he is not entitled to get any compensation, because he will have to get the compensation against the accidental vehicle, that is the truck. And your lordship will not find any sort of evidence against the negligent driving on the part of the truck. Now, on scanning entirety of the matter, your lordship will find he is not entitled to get anything, and the learned member very rightly, my lord, I will take your lordship to that para. Your lordship may kindly see at page 140, paragraph 60.
Yes.
Paragraph 60, my lord, I am referring. From the evidences discussed above and weighing the evidence of both claimants and OP number 3, it is found the version adduced by OP number 3 is more believable. The witness adduced by OP number 3 are all police personnel having no interest in the case, and OPW number 2 and 3 were on the line of their duty, and they had reiterated again and again that while other vehicle obeyed their signal and stopped their vehicle for checking, the driver of Maruti car did not stop at their signal but overtook the other vehicles who had stopped for checking and suddenly came and dashed the stationary truck. The claimant also could not shake the evidence of PW3 that the truck was not stationary but was moving, as when OPW number 3 was confronted with the evidence of OPW number 1 that as per OPW 1 the truck was moving at a normal speed. OPW number 3 reiterated that the truck was parked. Also, as per paper book D, there was smell of alcohol detected on the deceased. The evidence of claimant witness CW2 and 3 is less believable by this tribunal, as CW2 stated that in the accident he was not in a position to open the door and came out through the window and he was badly injured, but contradicted himself in the cross-examination that he was not seriously injured. CW4 has stated that he saw the incident took place and narrated the incident before the police officer present at Civil Hospital Nangpur, but in his cross-examination he stated that he did not inform the police on that day or any other day subsequently anything about the accident. After weighing the evidence of both the claimant of OP number 3, as discussed above, it is found that The accident was caused due to the rash and negligent driving of the deceased husband of the claimant, who failed to stop on being signaled by OP number 2 and OP number 3, who were on Naka checking duty, and then overtook the other vehicle and went to dash the stationary truck. So ultimately, my lord, it was dismissed. Now, so far the other, my lord, the decision, as my learned friend stated, my lord, there is no quarrel in the legal position, but only one submission he made in his written note, page 8, 1.6. Your lordship may see section 171 of the MB Act. The statute never indicated that is whether it is 12%, but he has stated, my lord, I am reading 1.6. Appellants are also entitled to interest 12% per annum as per section 171 of the MB Act. This position is not correct. My lord, as your lordship has seen, the Honorable Apex Court as well as the different high courts in the country, they are giving interest 6 to 7%. Seeing the inflation and all that, because the bank rate, as your lordship know, hardly they get 6 or 7%. So therefore, this legal position as stated in this petition is not correct.
Well, that is,
I am not required to argue that because he has no case at all.
Like you rightly said, the Supreme Court in many decisions has indicated that as far as rate of interest is concerned, it is not constant.
Yes.
It is not static. It is
Right.
It is dynamic.
That is for in general cases I am submitting that because he has stated that 171 suggests mandated 12%. That position is not correct.
True.
So therefore, ultimately, my lord, the entire thing boils down to the thing that when there is no evidence against the truck, my lord, there cannot be any compensation part against the owner of the truck, and therefore it was dismissed rightly by the tribunal. That's all, my lord.
I think Mr. Day also was here. He was for the driver, isn't it?
Mr. Day, I think for the driver.
He's not here today. Why?
I think he don't have.
It's not for you to say.
He has to say that.
Yesterday, last time he got scared. Last time he got scared, it may fall upon him.
No, driver.
But what to do? We cannot just ignore this. He was present all along.
Yes. He all along he was there, my lord. But today, surprisingly, he thought on that day it was all over.
Oh, can it be?
No mention made about him. No mention.
No, yes, the court cannot ignore this.
Yes.
He may say yes, he may say no. That
it
will be noted. But you cannot just say that he is not here, so we go ex parte against him.
Not ex parte. He has been participating once he has.
He should have been here. He should have been here. Courtesy demands that he should be. Matters in
see him today also.
Just because of him now, unnecessarily we are.
It also demands from him that he should either make a reference.
Exactly, that's one. He should.
Junior रहने से भी ठीक था ना?
We'll hear him then.
Hearing concluded.
As far as you are concerned, concluded.
So far he is concerned, my lord, if he want to say something, he can.
We can record the hearing concluded since Mr. Day was absent.
No. So far we are concerned, it is all over.
All over.
We'll just have to hear Mr. Day.
Yes,
what he has to say.
In case he wants.
Yes, he wants.
Let's fix it on short date, 1 or 2 days after. Otherwise, you are.
Mr. Datta, it's not necessary for you to be here anymore.
No, it's not necessary. It's all over. So far,
I am also not.
You have filed your written argument also.
Yes.
You have also filed.
I have also filed on the pontification.
Heard Mr. PK General Counsel for the appellant, who has concluded his argument. Also heard Mr. S. Datta, Leonard, Senior Counsel for the respondent.
Three.
Insurance company, who has also concluded his hearing, his argument. Mr. the respondent number 2.
Driver is 2.
Respondent number 2 who is represented by the counsel, Mr. PDA, is not present today as the counsel has failed to appear for the court today. However, for ends of justice, this court would grant an opportunity to the learned counsel for the respondent number 2 to be heard on the next date. This is matter to 1 week. 1 week is
much or less.
Item number 9.
Oh, okay.
You know, the KSI had been called for because they had produced a Caesar list which we wanted to confirm. So indeed, the learned counsel for the accused had given those documents to the IO, but he's also required for questioning. He has never appeared personally after the bail order was made absolute. And even before that, he's just appeared once.
Okay.
So investigation cannot be completed.
So, Ms. I, no, without going to this through this CD, you would concede that the seizure was made.
Those documents,
as far as those documents are concerned,
listed in the Caesar list, those have been. But then there are several other documents.
So in effect, Section 91 has been complied with.
There are other notices also that were sent to him. He's required, my lord, if he doesn't appear personally, how can the investigation proceed? There's another notice, my lord, sent. And if my lord would see the status report first, second last paragraph, where it stated that certain documents, those documents he has not supplied. That second last paragraph, the case is kept pending with no further development as the accused is not cooperating, and the missing document or files of the year 2018 up to 21 shows that he has tampered with evidence, etc. So now, my lord, what has happened is these documents from 2018 to 21 cannot be found at all. During the investigation, the police could not find it, and therefore he needs to come to the police station to explain. Now he is already protected. What is his fear? Why cannot he appear personally and answer certain questions?
Yes.
The law aids only the abiding and not those who kind of challenge the integrity of the judicial process and the security of the victims.
What do you mean to say?
All I mean to say is that the process of law has been abused, the integrity of the judicial process. He had been granted protection, he has not really honored it, and he's not cooperating at all. There have been occasions where they have tried to mislead the court, and therefore, my lord, what I would pray for is cancellation. Otherwise, he can also come and answer the questions so that investigation can be completed.
That is the commitment he has given. You were citing a certain date where he failed to appear, isn't it?
Yes, my lord.
There are several occasions, all of these notices, he has failed to appear on all these dates.
Okay. So on several dates he has failed to appear.
Several dates, and now a fresh notice has been again issued to him because the investigation cannot be completed unless he comes personally and answers the questions.
When was the fresh notice issued?
August, 5th of August, my lord.
Has he received the said notice?
No, my lord, we have no knowledge about this 5th. This is 5th. It was status report was submitted also before this honorable court.
5th of August.
5th of August.
Okay.
So we have
that's
not yet
only about last week or so.
Man.
You have not received?
No, my lord. In the status report also they have not said that they have issued the last status report.
It was issued after that.
It was issued after.
Then the moment we'll receive your lordship, we will comply. And so far the other dates is concerned, we have already given explanation.
Well, the only explanation for 1 date was given, but it's very obvious that once an investigation is going on, the accused needs to appear personally to answer questions.
Yes, of course.
That one.
Very well. I'll go through the submission of the parties.
Yes, ma'am.
Do you have any authority?
I have submitted, my lord, that Daulat Ram and one Delhi High Court, that missing of 1 or 2 dates, the harsh, it should not be cancelled on such a, it will amount to harsh punishment for him.
Lordship, if I can apprise Lordship. Lordship, from Bar Council I have received a letter that the accused person has complained against me in the Bar Council, Lordship, to cancel my license, Lordship, because I have repeatedly appeared on behalf of the complainant before the before both the bench, Lordship.
That is.
Lordship, I know, Lordship. That is not.
There is another course of action which you have to
Lordship, Lordship. But Lordship, the thing is that I have not gone into agreement with the accused person. Never ever. I am protecting my client, Lordship.
Yes,
and Lordship, if Lordship, he is not complying with the court order, the notices from the IO, and he is also not. I have not interfered in his cancellation of bail, Lordship. It has gone smoothly, Lordship. But Lordship, when on other case in 482, when I appeared, Lordship, he has lodged a complaint against me before the Bar Council, with also informing the Lordship to the Bar Council of India, Lordship, that my license should be cancelled, Lordship.
No, that is not related to this case, I think.
No, it is not related, Lordship. I have just apprised, Lordship.
But are you a party here?
No, Lordship. In cancellation, I am not a party. I have not interfered also, Lordship. I have not appeared. It is between the IO and the accused person. But, Lordship, my only contention is that, Lordship, what is his bona fide intention to complain against me being the counsel, Lordship? I have not gone into an agreement, Lordship.
My lord, I think she has appeared in other case without wakalatnama. That's why.
Lordship, that is a
I think not in
different
this
case altogether.
In other bench, there was one case wherein there was no wakalatnama and she was appearing for the complainant, and who has found ultimately died. And later on, it was discovered.
But that is my complainant and me, Lordship.
I think in other case, not related to this case.
The court has granted me time to file my substitution petition. That is a different thing, Lordship. But Lordship, I have gone through on requesting Chairman Sir, I have gone through the complaint. He has also complained that I am appearing for the cancellation of bail, whereas Lordship, I have never appeared in the cancellation of bail, Lordship. He has also made an allegation that I have opposed his cancellation of bail without proper authority, Lordship. But I have never opposed his cancellation of bail, Lordship. This is making a malified intention with coming before the...
True. Again...
If that is the case, Lordship, we will not be able to practice, Lordship. We are defending our client.
That is true. See, as far as that matter is concerned, you know what course of action to be taken.
Lordship.
You reply to the same and see. But as far as these matters are concerned, it's a different...
Lordship, it is a different matter, Lordship. It is a different matter. But Lordship, my only thing is that I have apprised this court, Lordship. Otherwise, I have I have no intention to interfere in the cases, but I have apprised the Honorable Court.
If the matter is within the domain of this court, but that is not so.
Well, I am relying on 2 Supreme Court orders where bail was cancelled because of non-cooperation because the accused failed to appear. My colleague would assist. My learned colleague would assist. It's the record of proceedings of Supreme Court. And the other is Hanuman Satedwar.
Para?
Well, it's a very short order. If my lord is having Durg Vijay Singh, then by way of present petitions, the petitioner has...
You're talking about this Shrikant Upadhyay?
My lord, I am on Durg Vijay Singh or Hanuman Satedwar. If my lord has... if my lord may kindly have Durg Vijay Singh?
Yes.
Durg Vijay Singh, by way of present petitions, the petitioner has challenged the order passed by High Court, whereby the High Court has allowed the application filed by the complainant and cancelled the anticipatory bail granted to the petitioner. The petitioner has also challenged subsequent order, whereby the High Court has rejected the subsequent application filed by the petitioner seeking anticipatory bail. Today, when the matter was being heard, the victim appeared through video conferencing and requested the court to permit her to appear in person. Thereafter, she appeared before the court. She apprehends, etc. Para 4, having heard learned counsel for the parties and having gone through the impugned orders passed by the High Court, it appears that the High Court, within the impugned order, had cancelled the anticipatory bail granted to the petitioner by observing that the petitioner was not cooperating with the investigation and was not responding to the call. Para 5, having regard to the said observations, we are not inclined to interfere with the impugned orders passed by the High Court. In Para 6, in that view of the matter, it is directed that the petitioner shall surrender to the concerned station, etc. Now, my lord, may kindly have the next one, which is Hanuman Satedwar. Leave granted. We have heard the learned counsel appearing for the appellant, complainant, and the learned counsel so and so. It appears that after the anticipatory bail granted by the High Court to the accused, respondent number 2 herein, he is not cooperating with the investigating officer, which is evident from the affidavit filed on behalf of the state of Rajasthan. It is mentioned in the affidavit that the concerned SI went to the office of the accused, but he could not be found there. And thereafter, the accused as well as his counsel was contacted on their mobile numbers, whereupon it was found that he is out of Jaipur. These facts establish that the accused is not cooperating with the investigating officer. In view of the above, it is necessary for us to set aside the impugned order of the High Court, granting this is about setting aside of anticipatory bail, because on grounds that the accused was not cooperating.
My lord, I have given
these are the 2 judgments only.
My lord?
These are the 2 judgments you are relying on?
2 judgments, my lord.
Okay.
My lord, I have given the chronological list of the notices which was issued. I have complied, my lord, and then only one on 17 January 2000.
He has never appeared. What is compliance? Compliance is that he appears or he produces the document. He has not done that.
Let us not go back.
Yes.
I've heard this.
So, my lord, that is the thing, only that on 17 January date was fixed. I have given the medical and then it was informed that they will inform me later. So, I have no intention that I will not comply. I have very much explanation is there. So that's why I did not. No, that one I have already submitted, my lord, that notice, that letter from me, which I have communicated to the IO. I have already submitted, my lord.
What the parties are? Passes the orders?
Yes,
this is another case.
Second call, item number 4.
Yes, miss. Have you filed your?
Lordship, the other case, this one is continuation of delay in the second one, Lordship. We are in process, Lordship. In the other case, we are filing, Lordship. We are in the process in the judicial sections. It is the other case we are filing, and this case, Lordship, it is fixed for in Sabita Devra's case. It is my cross appeal, and it is on condemnation of delay. And the hearing is fixed, Lordship. So, Lordship,
you file your application for condonation of delay here. Delay in filing the cross appeal.
Cross appeal.
Where is that petition? Okay, so no response has been filed as far as this.
I have filed my response.
You have filed?
Yes, Lordship.
And Mr. Sen?
So we not filed.
Obviously, he'll not, Lordship.
Yeah, because collector is a neutral person.
Well,
Collector is a neutral person.
No, I am willing to defend that case. If they want to get it set aside, then my learned senior said because there is no award, it should be set aside. They're making some legal argument. I have no role to play. This is the beneficiary of the project and the landowner.
But
it's between them.
But the beneficiary, the NHI, has no business as far as fixing of the rate is concerned. That is by the collector.
Oh, that's a different thing.
No, in an application under Section 5, I have no role to play. I'm saying it's up to them. It's up to your lordships. That's all.
Lordship, this cross appeal is under Order 41, Rule 22, Lordship. And Lordship, my delay is of 925 days, Lordship. And Lordship, it so happened, Lordship, when we came to know about that, Lordship, the award, copy of the award is not there on scrutinizing of record, Lordship. And subsequently, Lordship, we came to know when the award copy was supplied before this honorable court, copy of the award, Lordship. And I sought for instruction from my department, Lordship. And the communications, because of the ongoing project in Guwahati.
Okay, just in the appeal filed by the client of
petitioner, claimant.
Ms. Majumdar.
Yes.
You were made party there?
Lordship, yes.
She was a party there.
I am a party there, Lordship.
And you had, you had participated in the proceedings all along?
Yes.
Lordship.
I think hearing was also concluded or about to.
My part was concluded. The state had to reply. The collector had to reply.
So at that point of time, you realized that something is wrong, and you filed your cross appeal.
Lordship, it so happened, Lordship, after when on the process of hearing, Lordship, the copy of the award was supplied, Lordship, because as per Lordship, if Lordship can remember, Lordship, when the hearing was on board, Lordship, that time copy of the award was not there. So myself, Lordship, I was also not aware of, I was only on collector's market value, Lordship. So the main hearing has to be proceeded by the collector on the market rate, Lordship. Subsequently, Lordship, when the copy of the award was, I received the copy of the award, Lordship. Lordship, the copy of the award itself was a defective, Lordship.
So, look at, if I understand correctly,
Lordship,
when an appeal is filed,
Lordship,
against an impugned award or judgment or order, you have been with parties.
Lordship.
You are one of the parties, rather.
Lordship.
And you have produced all the materials on record, paper, everything. If you are also, at the initial point of time, if you are also not satisfied with the award, which has also perhaps gone against you, then that was the time when you should have filed your cross appeal. You did not.
Lordship.
But
Lordship, that is why
instead you participated in the proceeding, and later on when it transpired that the copy of the award was not on record, which was subsequently brought to the notice of all concerned, then you realize, oh, because the award is not there, so I have to file a cross appeal. A copy of the award is not there, so I have to file a cross appeal. But is that a correct approach?
Lordship,
And for that, even otherwise, when the appeal was filed, it was filed in, when was it?
2022.
2022.
Lordship.
So from 2022 till date, 900 days have gone.
Lordship, it is from the first date of hearing, Lordship. It is the 900 days because, Lordship, from 2022 after as per the sections, Lordship, as per the Order 41 Rule 22, Lordship, it is from the day of first hearing, Lordship.
This 5/12/2000.
But would see again since let me understand correctly. I may not understand the situation and the implication, but if you have been made, you are already a party in the appeal.
Lordship.
An argument is being advanced.
Lordship.
By the appellant and also the respondent, collector. You are also one of the respondent. You are also one of the respondent.
Lordship.
You could have advanced your own set of argument. State your case. What are you by which way you've been you're dissatisfied or not agreeable to the appeal filed by the appellant, to the extent that it has affected you. Because the main focal point would be the amount, isn't it?
Lordship.
The amount to which the appellant is not satisfied with.
Lordship. Lordship.
So why the necessity of filing a cross appeal?
Lordship, in the appeal, Lordship, the appellant has not challenged the judgment, Lordship. Lordship, here what happened, Lordship, I have challenged the judgment. In my cross appeal, I have challenged the judgment to set aside the judgment, Lordship. Because the award was not in a proper format, Lordship. The award has to be in a proper format, Lordship. To base of the case is, Lordship, the award. If the award is not in a proper format, Lordship, can the matter travel up to the extent, Lordship? The appellant is on the footing that market value has to be increased, Lordship. I am not on that footing, Lordship. I am on the footing that if the award is defective, Lordship, then the judgment is always a defective judgment, Lordship. Because, Lordship, the entire base of the judgment is based on the award, Lordship. And the award, in the award, Lordship, the award which is on board, Lordship, the award, the entire solicium is calculated on entire amount, Lordship, on the whole sum amount. Whereas the solicium has to be on the market value, Lordship. I can proceed with the length once my condonation is allowed, Lordship, and my appeal is on board, Lordship. I can proceed with further hearing, Lordship, that how the solicium has to be calculated, Lordship, what is the process of calculating solicium, and what is the how it has to be, and since the award was already when the award was pronounced, Lordship, it is a random award, Lordship. Just giving taking the entire whatever the amount is, Lordship, for the entire that project of Khanapara 4-lane project, entire project, the solicium is calculated 30%, Lordship, which is not correct, Lordship. The award has to be on market value. The solicium has to be on market value, Lordship. Further, all the interest is also there, Lordship. Incumbent which is been paid to the landowners, Lordship, furthermore, Lordship, on each and everything on scrutinizing, because when the reference was made to the lower court, Lordship, it was the copy of the award was not enclosed, and now all the cases in lower court is also suffering because, and all the awards are not in a proper format, Lordship. So the lower court is also keeping an eye on the High Court, that what will be the judgment coming on the award, based on the award. Because if a award is defective, Lordship, whether the judgment is at all
that could be a point for consideration.
Lordship, that is why, Lordship, it is also, I am not on interest, I am not on, presently I am not on market value. But Lordship, if award is calculated in a, not in a proper format, Lordship, then can the Lordship, the judgment be a proper, Lordship? So, Lordship, the judgment needs to be quashed, Lordship.
So what is your explanation for the delay?
Lordship, because after the first after the course of first hearing, because according to order 41 rule 22, it should be from the first day of hearing. After the first day of hearing, I intimated to the department, Lordship, that these are the loopholes of the case, and to take the call on the department, to call by the department. Department took some time, Lordship, which I got communicated later, and subsequently I filed this case, Lordship, on communication, after receiving the communication, Lordship.
That's it. Have you annexed those copies of those communication?
No, Lordship, I have not annexed the communication, Lordship. I have not annexed the communication, but the communication I have made, Lordship.
But you have to prove your bona fide.
Lordship, I have communicated, Lordship.
You have to prove that.
I'll because these are the letters, Lordship. I can easily through mail only I have communicated, Lordship.
You can always transcribe that.
I can take the printout of the mail and I'll provide.
Yes, get a printout and file.
Lordship, I'll take the printout and I'll supply it, Lordship.
What about the other parties?
I am there for the appellate in the other case. I have filed my objection. Respondent 3 and 4.
What is your objection?
My position is that this condonation petition is no condonation petition in the eye of law. No explanation, just a bald statement that the counsel for the respondent number 3, who is the appellant herein, has proposed to file a cross appeal under this and this, and the same took some time, and hence the delay. That is the only thing.
Exactly. That was
nothing. Not even that they were corresponding. Nothing. That would be improving the case now.
That is the query met by the court today.
Nothing.
I'll supply the copy of the letter.
If this court would not insist on an explanation of a day-to-day explanation,
no,
day-to-day or minutes or seconds, that
merit will come later, Lordship.
But the sum and substance of your contention has to be made clear.
Lordship, I'll supply the copy.
You are saying something, but without any, as Madam was saying, it is correct. There is nothing here. I've read your.
Lordship, I don't need to even file the affidavit, Lordship. This is a copy of the mail, Lordship. I'll take the printout, Lordship.
Someone has to take responsibility.
Lordship, if the matter comes up tomorrow,
I have to file it.
Lordship, I'll take the printout of the mail.
Affidavit has to be filed.
Affidavit has to be there. Someone has to take responsibility.
Lordship.
Where is look at your averments here. Nothing is said in para 3, nothing is said in para 4.
Nothing, Lordship.
5 maybe?
5, Lordship, talks about the merits.
Yes, talks about the merits.
Para 6 also, Lordship, that the delay approximately filing the present picture occurred due to the reasons.
Well,
Lordship, it is... Lordship...
What are the reasons stated above? No reasons at all.
Lordship, the para 3, it is like during the course hearing, I have substantiated, Lordship, order 41 rule 22. is after the first day of hearing, Lordship.
We are not talking about the length of the delay. We're talking about the cause of the delay, the reason for the delay. You have referred to certain correspondence. You file your additional affidavit.
Lordship.
1 week
Lordship.
will not delay, sorry, just taking unnecessarily.
And this is getting delayed because the matter is almost over. Lordship, a date may be given.
But this people study in our counsel for the applicant. They come miss case, miss case 1 of 2025. The learned counsel has submitted that. You're the counsel or standing counsel?
Counsel.
Standing counsel. Standing counsel. Applicant National Highway Authority has submitted that an additional affidavit may be allowed to be filed to allow the applicant to substantiate the cost and reason for referring the application under Section 5 of the Limitation Act for this court to condone the delay stated delay as has been indicated in the main application. On pre-made, seems allowed. Lays this matter on. You will set a date or depends on you?
Lordship, if Lordship fixes the date, then we can finish it off this matter on that day.
Yes.
If she gives us the copy before.
Yeah, that you can give advance copy. When do you want it? But just ensure that it has to be done.
Lordship.
That's over.
Lordship, it may come on 22 also, Lordship, because I'm not taking too long time, Lordship, because 15 is a holiday, Lordship. I'm not taking too long time.
This is matter on 22.
Will serve us a copy before that.